Hello everyone and welcome to Strategic Delusion. This is my video called A Litigious Rapper, an analysis of Drake's petition. This is part 1 where I will be overviewing the New York petition regarding the civil RICO case and the New York deceptive business practices. So before we get really into the weeds of it, I think it's really important to define what a pre-action disclosure is. Under New York law, it's defined by statute CPLR 3102C, which is before an action is commenced, disclosure to aid in bringing an action to preserve information or to aid in arbitration may be obtained, but only by court order. The court may appoint a referee to take testimony. It's really important to point this out because, as the petition states, they don't have sufficient evidence to file a complaint. And this is really important, particularly in this instance where we are dealing with a fraud case. And in paragraph 28 of this petition, you'll notice a reference to Rule 9b. And it's important to recognize what Rule 9b says. Rule 9b requires that for fraud cases that there must be a pleading that includes particularity, which is specific facts that support the inference of fraud. It's a heightened standard because fraud is something that's kind of easy for people just to claim that they've been fraudulently handled, what have you, but they need to show particularity. And what that includes is that for there to be a successful fraud claim, there must be evidence of scientur, which is the intent and knowledge of wrongdoing. Again, this is kind of something that's really hard to prove because you essentially have to say that they knew they were doing something wrong. It can't be, and this does happen a lot, where somebody accidentally finds themselves doing something that harms somebody else or just is doing the normal course of business and it harms somebody else, and that person might receive that as fraudulent behavior, but they might not have the intent and knowledge of wrongdoing, which is not a legal liability for fraudulent activity. So this is something that's really important. For this to be a successful claim, if they do intend to proceed with a complaint, they must show scientur. So I've just seen floating around a little bit that people say that this is a really strong case and why Drake has a strong case. Well, by virtue of this being a pre-action disclosure and them even including that we need this information in order to reach Rule 9b particularity standard, it's not a strong case. They need more facts and they don't have all the facts. And I'll also go into how the facts that they do provide are a little bit lean in terms of what I think would be necessary for a judge to feel really compelled to approve of an order. And so this is just to give context for what they would need to have a successful case and also for their complaint to go through to the next stage, which is that they need a basis for believing that plaintiffs could prove scientur. So I really implore everyone who's still listening to think about whether or not what they are seeing in the subsequent facts that I will illuminate, whether or not you believe that there's a basis to believe that UMG and Spotify had the intent and knowledge of wrongdoing. And I feel like this is something that a lot of analysis isn't touching on, but this is the basis by which we can assess whether or not this is a strong case. Another really important fact is to understand the elements of the civil action that is being proposed. So there are broadly two actions that the lawyers for Drake are presuming that they could take forward against UMG and Spotify. First is a civil RICO, which has a 4-year statute of limitation, and the second is a deceptive business practices, which has a 3-year statute of limitation. The reason why I mentioned the statute of limitation, or SOL as you see on the screen, is because there could be, I think there's a lot of questions of why would Drake do this. Now, in the Texas defamation case, and I'll talk about that hopefully in a future video, yes, he definitely needed to proceed with some form of action because defamation has a 1-year statute of limitation. But for this New York petition, there really was no rush. He has 4 years and 3 years respectively to pursue the civil RICO and the deceptive business practices. So I don't really think that statute of limitations was a motivation for the New York petition. With that being said, let's go into what he has to prove in order to have a successful case against UMG and Spotify. For the civil RICO, he has to prove, 1, that there was a violation of RICO, Racketeer Influence and Corrupt Organization statute and federal law 18 U.S.C. section 1962. 2, he has to prove that there was an injury to business or property. And 3, that the injury was caused by a violation of 1962. Now, the 1962 statute is pretty meaty, but essentially it says, is there evidence of racketeering activity? And then there's this very, very long definition of what racketeering activity is. I perused through that, and I think there's 2 causes of action that are most relevant to the present petition, which is 1, mail and wire fraud, which is why you'll see in one of the requests, they're requesting evidence that there was money exchange for the fraudulent behavior. And then the other, I believe, relevant racketeering cause of action is interference with commerce. So this is essentially saying that Drake wasn't able to pursue his normal course of business because of the corrupt actions that were taken by both UMG and Spotify. And then we have the deceptive business practices. And again, 3 elements. 1, whether the conduct was consumer oriented. So is this related to how consumers are buying a particular product? And yes, this is how consumers are buying music. 2, was the act deceptive or materially misleading? And I think this is where the bulk or the strength of UMG's defense will likely come if this ever proceeds to actual litigation. I think there's a lot to be said about how there was no deception or material misleading acts taken by either Spotify or UMG, but that is something that we can only assess when we actually get more facts. And I'll talk a little bit about how I think this petition is very lean with its evidence and its facts, even based off of what they do have available to them, despite the fact that they don't have access to UMG communications. And then, of course, 3 is, did the complainant suffer an injury as a result of the misrepresentation? And so with any sort of lawsuit, I think something that people have to realize that there is an ego trip attached to it. And I think in this particular case, if this does proceed to litigation, Drake will ultimately have to admit that he lost something as a result of Not Like Us going as big as it did. So that's almost an admittance of defeat, but he's going to probably want to also show the financial losses as well. So this might also open up a can of worms where he has to prove the difference between his earnings in 2023 to 2024, things that can be quite sensitive for artists to kind of bring to the forefront. So that is going to be something interesting to see if Drake is willing to take it there. And I do believe, quite frankly, that this entire petition, and I'll talk a little bit about my theory about the strategy behind this petition later, but I don't think this petition is really filed in order to pursue litigation. I think that they just want access to some emails and to cause a little bit of grief for UMG in the interim period. All right. So the next thing we're going to cover is just the request. And again, very important to keep these requests in mind. So ultimately what this petition is doing is it's requesting broadly these 3 things to determine, so that way Drake's legal team can determine whether or not there's a complaint here to pursue. So 1, they want the documents and communications, very important, including text messages to identify third parties paid to promote Not Like Us. And I get why they want text messages, because I think in artsier sort of corporate environments, they tend to be far looser with communications. But yeah, that could also get testy in terms of the judge determining the scope of the request. And I think that's going to be something that they're probably going to face a lot of issues with. And the first request is really just trying to figure out if UMG paid any particular influencer like NFR for any promotion. The second part is to identify third parties paid for stream botting. So that would be like that interviewee that academics had. So they want that communication. And 3, documents and communication showing an agreement to exchange promotion/stream botting for alleged payments. So that's going to be very key to filing a complaint that's actually going to be successful. So again, they have no evidence of any of these things. They're asking for them. And as one can imagine, the average corporation is not willing just to give up their communications willy-nilly. So I do suspect that there is going to be a lot of pushback. I also suspect that the judge is going to have a lot of questions about what this petition is really asking and why. What is the scope of, we can't just give you all the documents and communication. Do you have a time frame, cease or law? So I'm going to go more into how I think a judge might look at this. With that being said, judges are very, very different. And I understand that I'm also pop culture savvy, which the average judge is not. But I'm also going to give some context as to why I think a lot of the arguments in this petition are very weak. And again, you're trying to convince a judge to approve of using court resources to enforce UMG and Spotify to provide these communications. It's very possible that the court, depending on the judge it comes to, might just say, whatever issues y'all have, just figure it out yourself. It might ask for a meatier petition that actually proves more facts, and I'll show where there's a lot of, there's a lot of bone, not a lot of meat on this petition, and why I think things could have been written a little better in this petition, in my opinion. So here comes my analysis. Let's start with the most substantive, or the first substantive paragraph in this petition, which is paragraph 4, and it claims that UMG intends to saturate the streaming market with streaming 2.4 efforts. Now, I was interested in this because I didn't know what this really meant, and so it's like, wow, that's some evil stuff. I can't believe they would say that in an article. And so here's where I think my analysis differs from a lot of people's. I actually clicked those links in the bottom, the references, which is so important, because this tells you how serious somebody is or not, or a lawyer is or not, doing this. I did feel like this petition was a little rushed, and this is exactly why. You see, the article that was linked that says that is supposed to make the inference that UMG places emphasis on the saturation of the streaming market actually does not infer anything about market saturation, and in fact infers that UMG wants to support more protections for artists by focusing less on scale and more on maximizing customer value. And with that being said, I'm going to read an excerpt from this article that I highly recommend. It is written by Ashley Coleman in Bloomberg, and it's titled Universal Music Group's Music's Grand Streaming Vision Requires Cooperation. So this is the relevant excerpt from that article. Michael Nash, Chief Digital Officer at UMG, explained that the idea is to focus less on scale in streaming and instead to maximize customer value through various subscription tiers and by selling additional merchandise or branding opportunities to fans. While streaming has delivered robust growth to UMG for over a decade, Streaming 2.0 will represent a new age of innovation, consumer segmentation, geographic expansion, and greater value through both subscriber and ARPU growth, Grange said. And just for a little aside, ARPU means average revenue per stream. To continue, much of the strategy's potential upside will rely on streaming services continuing to increase their prices, while also launching compelling, pricier premium tiers that give listeners a reason to upgrade their plans. So that's basically it. And it goes into how Spotify is trying to create another tier, Supremium, which will entice more people to join their platform with high fidelity audio, which apparently Amazon Music and Apple Music already have. But yeah, it's basically saying that we want to create consumer segmentation and greater value by basically making the average consumer pay more for the music that they're getting. And I also found it really interesting in the same article that there was reference to something that I felt very relevant to actually this very petition. In this petition, or in this article from Bloomberg, they also referenced a court case, which is that 2 weeks ago, the Southern District of New York unsealed a court case in which a man allegedly used artificial intelligence to generate songs, which he then streamed with bots. The prosecution claims his scheme netted him $10 million. We don't know yet which streaming services paid out the majority of those royalties, though Spotify told me last week that it paid out only a $60,000 chunk. Okay, if I'm writing this petition, I'm looking into the Southern District of New York unsealed court case, because at least it's proving that Spotify was not able to identify that somebody was using bots to net him $10 million. I would use that then to say, look, they paid this person out $60,000. While arguably that is a small chunk of $10 million, it still infers that Spotify could have, blind eyes to the botting that might be happening on their platform. With that being said, there might also be a reason why the lawyer did not include this case, because then it goes back to this idea that for fraud, you require scienter, you require awareness and knowledge of the wrongdoing and the intent for the wrongdoing. So if you put in a case where it seems as though Spotify was unaware of botting happening on its platform, it takes away the ability to then claim that Spotify was conspiring with UMG in order to bot the system. So anyway, that's just something to think about. I go back and forth between whether or not they should have included more cases like this. But again, this is just paragraph 4 was my first hint that like this wasn't as strong of a petition as it could have been, because it's kind of throwing out the word saturating the streaming market and then linking to an article that does not reference whatsoever saturation of the streaming market at all. So that to me is just, and of course it's a lawyer's job to be persuasive, and unfortunately people do use very strange methodologies to persuade people, but that was my first hint that things weren't all good to go. And that brings us to the second substantive paragraph, which is paragraph 7. So in paragraph 7, it talks about how UMG charged Spotify 30% lower than its usual licensing rates for Not Like Us in exchange for Spotify affirmatively recommending the song to users searching for other unrelated songs and artists. That 30% number is really important, but I think more broadly, it's important to see how there's no further evidence for this argument in paragraph 7. And this contrasts with paragraph 10, where they do give evidence about how Siri was requested to play Certified Lover Boy and then it played Not Like Us instead. And I do think that it's kind of strange that they would just throw out this allegation, but like provide no other evidence as such. And I will also bring up another point that I found out through Rob Markman, but I'm just going to add a little color to it even more, which is, one, it's very hard to coincidentally have the same exact percentage that is available on Spotify's website. It took me all of 10 seconds to go on Google Google Discovery Mode, scroll down and find this infographic about Spotify's commission. I apologize for the sirens. I'm just not going to re-record this. I hope you heard me. But essentially, it took me a very short time in order to find that Spotify does have this discovery mode with a 30% commission available in it. And I do think that's important to note as well. 30% is not just an arbitrary percentage. I do think that there's something to be said about the coincidence that the argument of offering a lower licensing fee and then this 30% commission on discovery mode is the same exact thing. So that will be interesting to see if it goes further. Again, the next act that would happen with a petition like this is the judge declaring whether or not UMG and Spotify have to complete with the orders and provide the documents to Drake and Drake's team. So we won't really know how UMG or Spotify respond to this, but that is a very curious thing that I'm glad Rob Markman brought up, because I do think it's hard for that to just be a coincidence that they have the same percentage. All right, to the next substantive paragraph, which is paragraph 8. So, academics had an interview with a young man who claimed Kendrick's label offered to pay him $5,000 in points on Not Like Us for 30 million streams. So, there are several questions to this, and I think it's interesting because academics, who many presume to be a Drake ally, was very skeptical on that interview. And he also seemed to have a lot of caveats before the interview even took place, but primarily he was asking the primary question that I asked that I think he was also skeptical of is it a fair exchange, $5,000 for 30 million streams? And points on a song seem very difficult for even other producers and other collaborators on a song to get. So why would they give this to a botter? And then my second point is, like, is there precedent that botting a song early turns it into a hit song? Again, let's go back to that signature. In order for this to be a successful case, they will have to prove intent of wrongdoing. This whole interview was really sketchy from jump, and I think that if this litigation does move forward, it would be so fascinating to see this particular individual be subpoenaed. He probably never thought that being on an academic stream might get him subpoenaed in probably one of the most high-profile music cases ever, but yeah, that'd be interesting. I do have a lot of skepticism about the veracity of his statements. It does seem really far-fetched. I would think that if you could pay $5,000 for 30 million streams, I would think you'd see a lot more botting. Like, academics was out here talking about DJ Mustard's album and how it didn't do well. And it's like, if you could pay $5,000 for 30 million streams, like, DJ Mustard could have at least paid, some money, to get his streams up on that album that he had. These, and I'm not saying, I actually really love DJ Mustard's album, and I actually did listen to it. So anyway, these are just thoughts that I have. It's like, if this really is that cheap and that easy to buy, I feel like more people would do it. And maybe it is very common, and I wouldn't be surprised if it were, but I would just want to know how frequent it is and how much the numbers are, because that seems like every new artist would take advantage of this in order to get their career started. So that's that on that. I think a lot of people are skeptical about this interview, and I do highly recommend you actually reviewing this interview. With that being said, another interesting fact is that the link that you have before, it's like one of those commentary channels, and what's fascinating is there's so many commentary channels that talked about this, but Drake's legal team chose a very, very small channel that is clearly Drake like fans, and who really saw legitimacy in this video. And I thought that was really fascinating because of how many videos were put out at the time that academics had this video, and of all the people, this really, really small commentary channel got a shout out. So maybe he'll get more views and subscribers as a result of this newfound fame. All right, so next to the next substantive paragraph, which is paragraph 10, here we have Jeremy Hecht. So this paragraph implies that there's video evidence, shows that there's video evidence of Siri playing Not Like Us in response to users asking for Certified Lover Boy, and saying that UMG paid or approved the payments to Apple Incorporated for this. So I have two broad points about this. The first one, I think, is just a logical point. I feel like when you're in any industry, it could seem all-consuming, and it's like everyone's listening. Music makes so much money. But to compare UMG to Apple is like, we're getting into very strange territory there. And it doesn't make sense for Apple to accept money to institute a glitch into their already poorly reviewed product. Like, they have no incentive to do this. And I really don't think there's any amount of money that is going to incentivize Apple to actually make this work and make this happen. Which then begs the question, well then, what other explanation is there for this glitch happening? And I do think that there's another explanation for this glitch happening. So I was reading a New York Times article called How Siri, Alexa, and Google Assistant Lost the AI Race. And this was published in March 2023. So people have been far from blown away by Siri and competing assistants that are powered by artificial intelligence, like Amazon's Alexa and Google Assistant. The technology has largely remained stagnant, and talking assistants have become the butt of jokes, since including in a 2018 Saturday Night Live sketch featuring a smart speaker for seniors. So the first point is that this is far from the first sort of quote-unquote glitch that has happened with Siri or any other voice recognition assistant. They're just really bad at what they do, and I think they're very easily manipulated. And this next paragraph will kind of explain how they're easily manipulated by third-party actors, which is that Siri, Alexa, and Google Assistant are essentially what are known as command and control systems. These can understand a finite list of questions and requests like, what's the weather in New York City, or turn on the bedroom lights. If a user asks the virtual assistant to do something that is not in its code, the bot simply says it can't help. So I think, and there has been a lot of evidence, I believe there was this thing with Black Lives Matter too, where before Black Lives Matter kind of blew up, there was clearly somebody messing with Black Lives Matter and a question of asking what is Black Lives Matter, and people would have racist responses or what have you. And so I think it's very easy to hack Siri, and that makes sense, particularly if you understand command and control systems. So I don't think it's that hard for somebody to go and sort of mess up the command and control systems to say, when somebody asks for Certified Lover Boy, play for Not Like Us. And that doesn't necessarily implicate UMG in that. And again, I just don't understand a situation where Apple would be like, yeah, let's accept money for that. Like, it doesn't seem great. And I think Apple is first and foremost a very serious company, and Siri is one of its worst reviewed products. So it has a vested interest in people believing that it can ask it a question it actually can answer, because it makes its product look weak and bad if it can't answer or can't provide, the playlist for Certified Lover Boy. So that's my explanation. I do believe that Siri is easily hackable, particularly with this easy command and control system that is being used. All right, so let's get to the next paragraphs 10 to 12. This is a very blurry picture of Brian McKnight, which I'll get into a little bit later. But paragraphs 10 to 12 essentially argue that, or alleges that at least one UMG employee made payments to an independent radio promoter. And I do think it's helpful to actually read what this paragraph says. Because it was really interesting to me how this was framed. This is in paragraph 11, the second sentence. It says, Petitioner has obtained information from a third party indicating that at least one UMG employee made payments to an independent radio promoter, serving as an intermediary who had agreed to transfer those payments to certain radio stations and/or radio station employees. These radio stations subsequently played or caused to be played, Not Like Us, without disclosing that they had been paid to do so. I don't think there's a strong connection here that UMG employees or this radio promoter was paid to play Not Like Us. There are so many, so many high tier artists under UMG, and even this idea that they're being paid to promote, I don't know why they would be paid, but there are so many different reasons why an artist would be paid or a promoter might be paid by UMG. Who knows what's really happening? It does seem sketch, and I do think that there should be a strict line and boundary that UMG and any influencer and promoters should not promote anything without disclosure. But I don't know if they have enough evidence to truly say, again, remember that scienter necessity, which is that there must be an intent for wrongdoing. And I think that they're going to have a hard time with this one, proving that this was for Not Like Us and not for the hundreds of other artists that are under UMG that need promotion. So who knows what's that for? Again, I do believe that there should be disclosure of that. And fortunately, this petition does make an argument regarding the two lawsuits. And I'm going to talk about how one of them is silly. But it refers to a 2006 UMG payola case where UMG paid a $12 million lawsuit settlement and a 2005 suit with two radio promoters. So the $12 million lawsuit 2006 case was really interesting. Apparently, a radio promoter got paid like tickets and accommodations, and they even disguised payoffs as gifts to radio contestants. To get Brian McKnight songs played. I feel like that's really funny. I just want to bring that up. I know there's a lot of drama about Brian McKnight, but this idea of thinking that people had to get paid in order to play his music is a little funny to me. But then they also bring up this other case, and this is literally, again, this is paragraph 11, and this is the only sentence about this 2005 suit. Separately, in 2005, UMG was sued by two radio promotion companies alleging fraudulent pay-to-play practices. They didn't detail any of the reason what this pay-to-play was, and they didn't tell us the outcome of the suit. A lot of times this is hard, particularly in 2005, to find that. But again, the other fact that I want to bring up is that both of these suits that are referenced are over 15 years old. So that's something to also keep in mind in terms of these are really old cases and they don't have recent cases in regards to this that would show more relevant facts as to something that would be a pay-to-play. All right, let's go to the next paragraph, which is still paragraphs 10 to 12, which there's another allegation that NFR was paid to promote Not Like Us. I think it's interesting that the tweet that they decide to show is this tweet on page 7 of 17 that Kendrick Lamar's Not Like Us becomes the fastest rap song to reach 300 million streams. I think it's interesting, and I'll talk a little bit about this later, but it's an industry norm. You know, Pop Bass was doing this. Pop Crave is doing this. It's an industry norm to post when records are broken within the music industry. And the tweet does not infer a fraudulent relationship between UMG and FR. Yes, it shows that Interscope reposted it, but Interscope reposting it doesn't necessarily mean that there's any fraudulent behavior there. I think any company is going to be appreciative of these different blogs and websites or tweet pages for tweeting out this information. And we're now in the age of fandom and music industry where half of the industry is really led by these people online. It's not, these people aren't necessarily related to the music industry directly, but they're just commentators. And because of how quick and how 24 hours they are with just a particular genre or a particular artist, oftentimes these bigger labels who have themselves spread so thin, and that I will also get to that later, who are spread so thin with all the resources that they have to use for this expansive network of artists, don't necessarily keep up with this information. So there is some reliance on these pop craves and pop bass to inform the general public about these achievements of these artists, and it makes sense that Interscope would retweet it. So yeah, I just didn't like this because it also implies that tweeting about Kendrick's achievement can be traced to being paid to do so. And I do believe that this is a part of a strategy of the petition, which is to make people feel doubt about whether or not they could be allowed to post Kendrick's achievement. Because I think something that is not really talked about a lot is how this petition is also tarnishing the reputation of NFR. If it's true that NFR does not get paid by UMG, putting this in a petition, even though it doesn't go forward, even if there aren't legal consequences, if I'm NFR and I know for a fact that we have not been paid by anybody to promote anything, I'm really upset about this, because this is something that is going to ruin how people perceive the videos that we talk about and everything that we do. And that's not a great place to be in. So I also want to give a shout out to NFR and whatever the truth is. But if we are to infer that NFR is not being paid by anybody, this is really sad stuff that Drake put onto them, because again, this does ruin their reputation. And I do think that because they're a medium-sized type of platform, that they can be kind of bullied into sort of being more hesitant on how they praise Kendrick and maybe trying to praise Drake more in response to a petition like this. Another thing that is talked about in paragraph 12 is whitelisting, which they claim is the first time in UMG history that they removed copyright restrictions on YouTube and Twitch. But I just kind of chalk that up to it's anyone's right to give away their property for free. So when you think about it, if you are, Kendrick is the copyright owner of the songs that he's released, the reason why you copyright strike videos on TikTok, on YouTube, on what have you, is because you need to recoup the money that is being paid by these platforms, because that's actually your music, that's your song, and you don't want other people benefiting from it. But if you decide to give that property up for free, that is your prerogative. And I don't think that there's anything necessarily illegal or even, quite frankly, immoral about that. In fact, a lot of streamers and reactionary channels were praising this decision because they were able to make money off of this beef. And quite frankly, I do remember that Drake is also rumored by No Life Shack of doing the same after Kendrick was credited for his efforts. So it's kind of weird that this would be put in there. Again, this is something that you have to realize that, and I do think that the lawyers wrote it in this way because they understand that the judge that's going to be getting this petition is not going to be in the know about the details of the beef. They probably don't even know the beef happened. They don't care. Just imagine your average 50 to 70-year-old older person who's basically sitting down reading everything from, disputes from chicken manufacturers to shipping issues to real estate. And so they don't know anything about these facts, and that needs to really be contextualized in terms of why this petition would be persuasive potentially to a judge. But I think even a judge that doesn't have any information is probably going to require more information to feel comfortable using court resources to order UMG and Spotify to release those documents. So now let's go to the subsequent paragraph, which is paragraph 17, or substantive paragraph in this case, which says that annual incentive program at UMG is based on the UMG divisions and not UMG generally. They allege that the annual incentive for Interscope CEO John Janik, who is pictured here, is 90% based on the financial success of Interscope and only 10% on UMG generally. Therefore, they were incentivized to promote NLU. Now, I'm going to admit, the first time I read this paragraph, I was like, wow, really, wow, I can't believe it. And then I thought about it, and I reread that paragraph 2 or 3 times. I was like, That's normal, right? That's normal business practice. It makes sense. You want to prevent a division CEO from sitting on their laurels and benefiting from the efforts of another division CEO. Because you can imagine a situation where, like, especially at a place like UMG, people are just like, you know what? I heard that Taylor Swift is going to release like 20 versions of Tortured Poets. We don't gotta do nothing. Everybody sit down. Everybody sit down. Like, I can totally see that. This makes sense. It doesn't, to me, again, that scientific, this idea that they understand that they're doing wrongdoing and they're intending to do wrongdoing. This is necessary in order to have a successful complaint regarding fraud. I don't think that this is going to reach that level. This doesn't make sense to me as fraud anyway. Of course, they're going to promote Not Like Us. That is their job. It is their job to promote the songs under their label. And with all these fans that are constantly complaining about the marketing of these industries, for there now to be some sort of issue that a CEO is incentivized to promote songs in order to get a bonus, I don't know. That it just makes sense to me. So I think that's just standard business practice. And we'll kind of get to the last substantive paragraph here, which is paragraph 18, which basically says that there were attempts to conceal the scheme by terminating employees associated with or perceived to have loyalty to Drake. So the first thing I thought of, actually, and this is just based off of my own understanding of what's happening, was I remember that in the midst of the beef, Vince Staples was actually having some convention interview. And one of the comments he made was how they were just firing people. And then I Googled this and I found so many articles about so many music industry players. Warner Music, EMI, I forget who they're under, had to like cut a lot of people. Tidal is cutting a lot of people. And then, of course, UMG. So this is from an article that was published on October 4th, 2024 in Billboard, and it was written by Glenn Peoples. It says, how recent music layoffs compare to the post-Napster years. So there's just been an extreme amount of layoffs within the music industry in the past year or two. And here's sort of an explanation for why that is. UMG, which went from an average of 8,800 full-time employees in 2020 to just under 10,000 in 2023, began laying off staff in March as a part of a restructuring that will save an estimated $270 million annually. Likewise, Spotify ballooned from about 5,600 in 2020 to 8,360 in 2022, before laying off about 25% of its workforce in 2023. Goddamn, 25%. I'm sorry, I did not mean to curse. 25. That I shout out to anybody who's been laid off as a result of this. But what I do intend to share is that layoffs in this music industry has been something that has been happening for the past year and a half. And it seems as though under COVID, there was just this spurn of hiring, and now they're just trying to lay low and keep costs low. And I understand how this might also affect Drake particularly. I was trying to get up and read some about Drake's $400 million deal with UMG, and I did find a Variety article, and it did detail how Drake signed his deal with UMG in the midst of COVID, and how that might affect what the terms of that deal is, because in the midst of COVID, there was a lot of question marks about what the industry was going to be in the future. And not only that, I can imagine that a lot of staff that was hired in that between that 2020 to 2023 period at UMG might have been hired for Drake. You can imagine that being the case because he was signed on to them around 2020 to 2021, I believe. So I can imagine that a lot of those people, or some of those people, were very loyal to Drake. But that doesn't necessarily mean that they were fired because they were loyal to Drake. They're fired because the company is trying to save an estimated of $270 million annually, or at least that's an alternative, an explanation. Then these people are just being fired because they like Drake. The entire music industry is contracting. It's getting smaller. These businesses are trying to find ways to maximize profit by minimizing their size. And I think a lot of artists, again, Vince Staples claims that he was hurt by losing certain staff members and that he really misses their presence in his career, in his life. Unfortunately, he's now independent. But this is just something to keep in mind, that throughout the music industry, people are losing their jobs. And so this brings me to the final substantive paragraph, which I found very interesting. And I'd just like to have more of a conversation about what the average person thinks about it. which is that streaming and licensing is a zero-sum game. This is what the beginning of paragraph 19 says. And every time a song, quote unquote, breaks through, it means another artist does not. Do you agree with this? Because I really didn't as a music consumer. And it also made me look at Drake and how he collaborates with other people a little bit strangely, right? Because it's sort of like, why do you have all these joint albums and have all these collaborations? And then, the story that, people like academics and Mal would like us to believe is he's doing it because he's bringing up their careers, he's making them big. But if he believes genuinely that streaming and licensing is a zero-sum game, then there might be more nefarious intentions behind, putting people on your song. Because if you have a whole album with another artist, like 21 Savage, like a Future, then essentially he's kind of like, I don't have to compete with you. I get to have your market share of the market because now I don't have to compete with you in this zero-sum game. And I feel like this does not create a collaborative spirit. And it kind of makes sense why Drake might have such a fraught relationship with so many people if he truly believes that streaming and licensing is a zero-sum game. That means every time somebody sees success, he always thinks that success is taken away from his own. And that's just a toxic way to live. I really, truly think it's just a toxic way to live. Even taking away whatever you think about Drake or Kendrick, I just hope that he's able to move past this. And I understand that this is just a petition. And I understand that, the lawyers are trying to write something that is persuasive and showing like, you see how bad this is? Because every time Kendrick does well, that automatically means that Drake doesn't do well because they have to prove, the elements, which we'll get back to. And that's why it is the way that it is. But I just think that this is a really nasty way to live. And if anyone out there listening, if you're still listening, thinks that, please change your ways. So that brings us back to, again, the elements of the causes of action that they want to potentially take against UMG and Spotify, which is the civil RICO. So we need to prove that there's a violation of the RICO, an injury to the business, and that the injury was caused by a violation of Section 1962. And again, recalling that they need to prove scienter. They need to prove knowledge and awareness of wrongdoing and intent of wrongdoing. So there was an intent to commit mail and wire fraud, and that there was interference with his commerce. And then with the deceptive business practices, we need to understand whether or not the conduct was consumer oriented. I think we've gone over that pretty clearly, that this is about consumers and how they are consuming music. Was the act deceptive or materially misleading? And then finally, did the complainant suffer any injury as a result of this misrepresentation? And so I'm going to take a little pause here. And based off of all that I've talked about in this video, do you believe that Drake's lawyers have a really strong case here? Now, again, Drake's lawyers themselves know they don't have a strong case, which is why they filed a petition and did not file a complaint. But this is essentially broadly, if anyone's wondering how the practice of law feels, what law school feels like, this is what it is. You have to know what the elements of a cause of action are. You have to look at the facts. You have to try to fit the facts to fit the cause of action, the elements of the cause of action. And then, of course, look at precedent to see what actually falls under that cause of action. And boom, you're a lawyer now. Just kidding. But kind of really, that's really what it is. So the petition is supposed to get us closer to this. And I just simply don't think it is. I do not think there's a lot of meat on this bone. And I think that more likely than not, the judge will probably ask for to give us more. Tell me a little bit more so I can see if I need to approve this action, or maybe even just say mediation. If he does approve the order for the documents to be provided, he's probably going to ask a judge. That was very misogynistic of me. He or she or them are going to ask whether or not what is the scope? What do you actually want? You got to be a little bit more clear about what communication and documents you're looking for, because, we can't just give every single document in that regard. So now I'm just going to go to a little bit of my thoughts and opinions, which kind of was this whole entire video, but regardless, why would Drake file these petitions? All right, so this is my theory. 1, this is an industry-wide cease and desist letters. For those of you who don't know, cease and desist letters are usually filed in regards to copyright or defamation, basically telling people to stop their activity, and that if they don't, they intend to pursue legal action. There's some statutes that actually do require you to have some form of cease and desist letter in order for you to be able to pursue action. But I think in this case, I think Drake is tired. Drake is upset. For example, I haven't heard a lot of people talk about the Billboard Music Awards. You have to understand that For All the Dogs was supposed to dominate this year's Billboard Awards. And now Kendrick, who hasn't released an album that's even eligible for this year's Billboard Music Award, is challenging Kendrick for a lot of these awards that usually would be in the bag for him. So these are all really frustrating elements. And I think he's basically saying there's a desire, I believe, from Drake's camp for people to feel a little bit more anxious about how they praise Drake or how they praise Kendrick, which is why that NFR tweet was put up, which again, I feel like that was so random. It's like, yes, that's normal for people to put up a tweet regarding the records that are broken under a particular artist. That's very industry norm. But he also, clearly, a lot of people have suggested he doesn't want Not Like Us to be played at the Super Bowl. That makes a lot of sense. NFL probably is going to try to avoid any lawsuit if possible, even though, again, I think there's a lot of ways that the NFL could protect itself. But he's basically trying to tell the entire industry, all right, you're not afraid of my tweets. You're not afraid of my Canadian gangsters. You're not afraid of my people. You're not influenced by what I do. Fine. You're going to be afraid of the law, though. And I think that that's unfortunately what is happening here. But I think just like a cease and desist letter, which I highly recommend if anybody gets one, do seek the counsel of a lawyer to determine the merits of the causes of action that are being alleged against you. Because while, yes, a lot of cease and desist letters you could just throw away, there are cease and desist letters that you need to take seriously. For example, I'm sure Tasha K wished she took Cardi B's cease and desist letter seriously. You just need to understand what are the merits of this case that somebody might have against you. In any case, but like a cease and desist letter, it is up to all the different actors that might be involved in the Kendrick and Drake beef to just determine what is the true harm here. What is going to really happen? And I think actually for the people that Drake wants to intimidate the most, they're actually the people who are going to be intimidated the least by this petition. Secondly, there's clearly a desire to influence internal politics at UMG. I don't know what's happening at UMG, but I can't imagine that somebody like Drake feels as though his stature within that space has changed dramatically. But I feel like they still want to recoup money, and I think he should take advantage of that. They still want to make money off of him. So I don't know. I understand he might want to take a break or what have you, but I would argue that it's not even been a year. And I think that he's kind of going into the desperate category way too soon. And I understand that things move very quickly in society, but a lot of people, especially after the beef, were like, Drake is going to be fine. Drake is going to take a break and he's be fine. And I still think that can be true, but I think Drake has to be a little bit more strategic in the way that he operates. And then finally, kind of alluded in my first point, I think he has given up the battle of winning the cultural battle, which I get it, but society is very fickle. Society is very, very fickle. The rap world is very fickle. People said that Gunna was never going to come back. He's a snitch. And then he's number one on the Billboard. So, you know what I'm saying? Like, yeah, sure, people don't like you for doing certain things, but there are ways to recover from certain acts. And probably the best way to recover is just keep on moving forward, which is exactly what Gunna did. Which is exactly what a lot of people did. Jay-Z also lost a battle. And I do think that battle was different because there was seemingly mutual respect to an extent between Jay-Z and Nas, but they said really nasty stuff about each other. And now they're friends, or friendly, and I think there's a lot to be said about that. And also Jay-Z is now a billionaire. So I just feel like this idea of losing a beef kind of being the end game it's not it. And the way Jay-Z and even someone like Ja Rule was able to act after, a beef kind of tells you what their future could look like, right? Ja Rule clearly doesn't have the greatest future or the greatest present, quite frankly, and he's been involved in things like Fire Island or what have you, but he still has something there. And I feel like Drake shouldn't try to just burn the whole house down before we even get to the year anniversary of the beef. So yeah, this is why I think Drake would file it. And my main thesis is that this is an industry-wide cease and desist letter. And then the long-term effects, I think a lot of people forget how long litigation is. I see a lot of Drake fans saying like he's going to win the litigation. I feel like you don't realize how bad it's got to get if litigation is going to move forward. I do believe that I don't think UMG would settle. And it sounds like a lot of people think UMG would settle because of all the mess, but I think UMG is not going to let any artist get an inch of thinking that this is a possibility of happening. And UMG will employ the nastiest law firms in order to ensure that the precedent in federal courts is that you are going to get, if you try a lawsuit like this against them, it's not going to end well for you financially. They could also require Drake to pay legal fees, even in regards to responding to something like a complaint. So it might not end well for Drake. And I do think that this is just like, because this is a petition, this is just like a look, you thought I want to do it, I'm going to do it. And I think UMG is just going to sit back and say, well, then do it then. Let's see how this goes. And I think UMG is going to have a lot better chance in the actual litigation of it. But here's what long-term effects of it. If he actually pursues litigation with UMG, which he's still signed under, right? It's gonna be very hard for him to make music and to tour, which is how he primarily makes his money. So, like, you could say that this is really restrictive and this is unfair, but I think the average person understands you don't sue your employer while you're still reliant on them because you're employed by them and you don't have enough savings to not rely on them for your rent, right? Like, if you genuinely need them and their money, you should not be suing your employer. And I don't know what Drake's financial situation is, although that gambling, the way he does that, I don't know how somebody can have even a savings account with those types of habits. But, if he continues with this litigation, UMG can make his life really difficult in regards to doing the thing that makes him the most money. Then finally, for probably 2 or 3 years of litigation, his name is going to be connected to Not Like Us in the headlines. He's probably not going to be releasing music. So you're going to have in the background everybody else, all of his peers, all of the new people coming up releasing music. And then every time Drake's name comes up, it's going to be like, in the preceding Not Like Us litigation. Like, that's just not something that you want. And I think it's going to, it's definitely going to hurt him more than it hurts anybody else. And then finally, and I think the saddest thing, and I think the thing that Drake probably wants the least, is that rap is going to move beyond Drake as he deals with litigation over a song he wants everyone to forget. So there's the irony there. All right, I've talked a lot. This is my first video ever. I have to do some edits, but if you have listened to this far, thank you so much. I'm going to try to put as many links as possible in the description, but that might take a while. So thank you again, and I will see you in my next video. Bye.